Much obliged, Your Honors.
No questions. Please go ahead.
Much obliged, Your Honors. Dr. Kumar's report conducted a significant detailed analysis and held that 18 out of 21 parameters are same, with only certain minor differences. Your Honors, it is submitted that this report cannot be ignored. Further, Your Honors, it is also submitted that a survey was commissioned by our legal team of Artisan Heritage, wherein among 500 respondents, 43% believed there to be some connection between the designs. Your Honor, secondly, it is submitted that there is no error on part of the commercial code in determining eternal blossom and eternal bloom constitute infringement under trademarks. Your Honors, the law regarding trademarks is highlighted here. It is basically law regarding trademarks states two factors. Firstly, that there shall not be any there shall not be any consumer confusion. Secondly, consumers should be able to associate the particular trademark with the particular proprietor of that trademark. In this regard, it is submitted that the respondents' use of eternal blossom constitutes trademark infringement under Section 29. Your Honors, in this regards, deceptive similarity, criteria for deceptive similarity was laid down in the Cardilla case and was also upheld in Parle Products Private Limited versus JP Mysore case. It is submitted that the criteria has to be threefold: conceptual similarity, visual similarity, and phonetic similarity. In Parle case, phonetic similarity was stressed. In Parle case, the conceptual similarity was stressed upon, wherein the court laid down that the broad and essential features of the two designs are to be considered. Your Honors, in this regard, it is submitted that blossom and bloom are deceptively similar to each other. Your Honors, reference is made to the landmark case of Make My Trip India Private Limited versus Make My Travels Private Limited. Paragraph 18, page 29 of the compendium submitted by the appellants, wherein it was held that leaving the Make My mark aside, trip and travel, though not phonetically and visually the same, they were synonymous to each other, and thus the whole mark was deceptively similar. A similar thing was held in the case of KRBL Limited versus Parveen Kumar Buyani and others, wherein the marks were Bharat Gate and India Gate. Now, Your Honors, Bharat and India are in no way phonetically similar, are in no way visually similar, but they are conceptually the same. Thirdly, Srinath Heritage Liquor Private Limited versus Allied Blenders and Distilleries Private Limited, 2015 Delhi High Court judgment. A similar observation was made in regards to the trademarks officer's choice and the collector's choice. Your Honors, in this regard, in the last pages of the compendium submitted by the appellant, the reports are attached, wherein the Dictionary of Merriam-Webster and Cambridge Dictionary states that bloom and blossom are synonymous to each other. Both of these words denote flowering, and also they are phonetically similar. Your Honors, if the report could be, if the pages of the dictionary could be referenced. Both of these terms denote flowering and thereby are similar. Use of the terms, in addition to the design which has been published by us, is an indicator of the fraudulent and malified intention on part of the respondents. Thirdly, Your Honors, it is submitted that the test in trademark infringement is that of consumer confusion. It's submitted that this test has been satisfied. Your Honors, the test is not about the whole consumer population being confused as to a particular mark, but even if a single consumer is confused, or even if there is a possibility of consumer confusion. Indeed, much obliged.
Counsel, could you please tell or inform us under which subsection of Section 29 are you pleading your case?
Your Honors, we are pleading our case under Section 29(1), Section 29(2)(d). 2B.
All right.
Much obliged. Much obliged. Section 29(2)(b), Your Honors. Your Honors, it is additionally submitted that Subway IP LLC versus Infinity Foods and others, if I may, it's a recent 2023 Delhi High Court judgment. In this case, it was held that standard of confusion is such that if I go to a store to get a particular product and I get the other product and I am not confused and I believe that the product that I got is the product that I wanted to get altogether, This is the standard of confusion. Your Honor, Section 29 2b points to indirect confusion, which has been created in our case. The confusion is regarding association. Uh, is regarding association. Your Honors, in the case of Parley Products Private Limited, which relied on Canon Kabukishi Kaishawa versus Metro Goldwyn Mayers Incorporated, it was held that confusion can be direct. Much obliged, Your Honors.
Could you advise us as to what is the difference between the two terms used under Section 29(2)(b), confusion and association? Are they same or they are different? And if they are different, then what is the difference?
Much obliged, Your Honors. Your Honors, confusion in regards to trademark law refers to the consumer confusion. As I have mentioned earlier, the standard in trademark law is not whether trademarks are basically advertisements of the brand. They are the brand's goodwill, they are the brand's reputation. So if my goodwill is being capitalized by someone else and they are selling my products in a way of in by presenting that they are associated to me, that is something that is legally a wrong. If that answers your questions, Your Honor.
No. So are you talking about that the confusion that there is an association? Is that what you're saying? Or are you saying that though
Indeed,
there is no confusion, but there
indeed,
is an association?
indeed, I'm arguing that there is a confusion because of the association, and I'm saying that there is confusion among the consumers, and as a result, they are associating the two products together.
Then why would the legislature use the two terms if they mean one and the same?
Your Honors, that is something for that would be something for the legislature to answer. But this presents a remarkable opportunity to this honorable bench to set a precedent as to Section 29 to be in itself.
Sure.
Much, much obliged, Your Honors. Your Honors, it is also submitted that the average consumer test has been satisfied, and in this regards, two evidences are presented. Firstly, the responses of the consumers. Secondly, the survey which has been presented by us, wherein 500 people who had purchased the products from either of the brand thought that there was an association between both the brands. 28% of the people thought that the products were designed by Anya Malhotra in itself, and 19% assumed it to be a licensed collaboration. Only 10%, which means only 50 people were able to identify the products as completely different. Your Honors, this 10% sort of also proves that the survey that we have conducted is authenticated. Because if we were to manipulate the results of the surveys, we would have made it as per our liking, and we would have made 100% consumers being confused. Therefore, the authenticity of survey cannot be under question in the relevant case. Your Honor, surveys are also one of the most prominent way of identifying commercial consumer confusion, as identified in United States Patent and Trademark Office versus Booking.com. Your Honor, now that we are the council is majorly done with the first leg of her argument, we would like to ask the honorable bench if the council may be allowed to share her screen.
Yes.
Your Honors, what do you think? Which design is this? Is it the applicant's design or the respondent's design?
See, you cannot ask the question to the bench. You have to show both the designs and compare it, because
Much
ultimately,
obliged.
the court has to see both designs side by side.
Your Honors, a side-by-side comparison is also presented by us in this very image. So this image was shown to the bench earlier. This is the applicant's design. This is the respondent's design. So
Right.
if the bench were to act as an average consumer, they would not have been able to tell the difference between the two designs, such as the level of similarity between the two designs.
Yes, but is it not that the classes for the goods are different? Because
Indeed not, Your Honors. Your
yeah.
Honors, both of the trademarks are registered in Class 24 and Class 25. The consumer base that they cater to overlaps. And moreover, in an online era, you can't argue that mode of supply or mode of sale are different. Both of them have online presence as well. Thereby, it is submitted that this would lead to numerous instances of consumer confusion, and it would harm our goodwill, and it would cause like significant financial damage to us. Much obliged, Your Honor.
Yes,
I don't.
is it registered? Is their mark registered, or it's still applied? What is the
Your
status?
Honor, Your Honor, in regards to the trademarks, it is submitted that they have filed an application. That application is under consideration.
Have you filed opposition?
Indeed not, Your Honor. The application has not been advertised as of yet. However, once the application is advertised by the trademark registry, we will file an objection.
So what is the process? Once the advertisement, what is the timeline for filing opposition?
Your Honor, I believe it's 60 days in under the Trademark Act that once the design has been advertised by the Trademark Registry, a person can file an application opposing the design, objecting to the design within this time period. However, the council would get back to you as to the exact number of days. Much obliged, Your Honor.
Yeah, you have tried to establish the similarity of marks and the causation of confusion amongst the public, but you have not delved much on the aspect of similarity of goods. Just by stating that the goods belong to the same class, I think the requirements of section 29(1) and 2 are not satisfied. 2, you stated that because it is online, both the goods are available online, so we need not do that. We do not establish the similarity because the channel is online. So that way, the concept of similarity of goods just goes to the winds.
Lord, Your Honors, the council humbly seeks apologies if the words came a little wrong. We are not saying that because both the goods are present online and therefore the question of similarity does not arise. We are merely putting a thought in the mind of this learned bench that them being online does not mean that their consumer base differs much, because the contents that are circulated online are accessible to each and every person and can create significant consumer confusion. Additionally, Your Honors, we do agree that the exact goods that are present are not with us. We merely know, as per the fact sheet and the annexures, that the goods in regards to which the trademark has been registered and the goods in sale of which both the parties are involved are fashion accessories and textiles.
All right, please carry on.
Much
But
obliged.
isn't it that you visited their store and purchased the goods?
Indeed, Your Honors, an extension of a minute just to just to answer this query.
Yes.
Your Honors, a reference being made to paragraph 14 of the Moot proposition. Anya visited Luxura store in Nixaria city and purchased samples of their product for the testing. Your Honors, our products have been available in the market since April of 2022. Since August of 2022, and we did not purchase the products as an inspiration for our products. The purchase was merely to clarify the claims which have been made by numerous people who have been tagging us in posts regarding the Luxura collaboration, etc.
Okay.
Much obliged. It was an honor arguing before the learned bench. My co-counsel would be dealing with the next two contentions, Your Honors.
Yes. Yes, please go ahead.
Much obliged, Your Honours. Your Honours, the Council seeks permission to address the bench collectively as Your Honours and Your Honour individually.
Yes.
Much obliged, Your Honours. Your Honours, in the case of Artisan Heritage Private Limited versus Luxura Textile Private Limited, this is the Council on the behalf of the appellant and shall be dealing with contention. Ideas shall not be protected, but the expression should be. However, Your Honours, in the pertinent matter, the copying goes beyond the general idea to specific protected expressions of design methodology, composition, as well as narratives in threefold structure. Firstly, that the appellant's work is original and protected under the Copyrights Act, followed by that there is infringement of the copyright by respondent's promotional booklet, and lastly, that not just the copying rights, the IPR rights have been violated, along with the moral rights of the appellants under Section 57. One of the copyrights artistic and musical works. Your Honours, originality has nowhere been defined per se. However, there have been various landmark judgments nationally as well as international jurisprudence which has established originality test. Your Honors, currently the courts rely on the 2008 Supreme Court judgment, that is the Eastern Book Company and others versus D.P. Modak and others judgment. Your Honors, in the case, it was laid down that if there is sufficient skill, labor, brain have been experienced, levels of creativity have been engaged in some work, which has literally a very small amount of creativity present, even that amounts to original work. Your Honors, however, that is, it is led that the amount of originality required in the case of a compilation is not very high, and even a small amount of originality is entitled to protection. However, Your Honors, if you refer, the bench is kind enough to refer again to para 5 of the Moot proposition, it clearly states that the appellant's book, which runs up to 156 pages, contains 47 original photographs, 23 hand-drawn sketches, along with 12 chapters on the narratives behind the lotus symbolisms. Therefore, not just the mere modicum of creativity is substantiated, but also the small amount of originality that is to be presented is there. Your Honors, therefore, it is contended that our originality lies not just in the idea that the respondents may claim belongs to the public domain, but also in the selection, in the coordination, as well as the arrangement of pre-existing data. Your Honors, the Council seeks permission to share an exhibit which compares the expressions of both the annexures that are there in annexure A along with annexure R, which are referring to the same deities in the lotus symbolism. The appellant would not have bought this case if only the similarities was restricted to the mentioning of deities and the cultures and the metaphors. However, Your Honors, if we notice the sentence structure that follows, that even the references being made to these deities is in the similar order, even that is, it is followed by Lord Brahma, Saraswati, and then Lakshmi, followed by the Buddhist mantra. Your Honor, this analogy that is being followed clearly describes that how it is merely copyright action that has been there. Your Honors, once established that the appellant's work is original, the another part that comes into the scenario is Section 14 that provides the exclusive rights regarding the adaptation, the production, the communication of the work. Your Honors, this is the very right that has been infringed by the respondents in this case. Your Honors, it is further contended that in the along with these two similarities in the expressions, the analogy that has been followed in the evolution of the both the designs, that is also a part of both the booklets, is quite similar. Both are having the evolution from a circular centric expression evolving into the 13 segment representations. Your Honors, per se, if the respondents come and argue that lotus belongs to public domain and can be expressed, we agree to that. However, if it was not the creative expression being copied, why didn't they just refer to the lotus in pink color? That belongs to the public domain, Your Honors. However, the very creativity of our design, or even in the sketches presented in our booklet, is entirely on the color palette of amber and orange that is there. Your Honors, further, the Council shall proceed with the second subcontention that infringement has taken place under Section 51. Your Honors, Section...
Before you proceed, Counsel, what is the ground of appeal against the observation of the learned commercial court on the idea expression dichotomy? It's recorded in paragraph 17 onwards. So what is your ground of appeal? What is the error in this observation?
Indeed, Your Honors. Your Honors, idea and expression dichotomy exists when there are very limited ways to demarcate what the idea is and how it is being expressed. However, Your Honors, we agree that giving reference to lotus temple that is there, or to the deities, or to the mantras, belongs to the public domain, and therefore being expressed in the similar manners is going to exist. Your Honor, but our appeal relies on the ground that firstly, it is not merely the expression in the narratives that is copied. In copyright, we are considering the entire book that is there. which includes not just the narratives being the same, but also the sketches and the evolution methodology of the sketches being same. Your Honors, not just the narrative are similar, but also the analogies as already established that they are referencing is not the problem in here, is not in question. But even in
But
similar
if you compare both the in terms of copyright, the sentence structures are different. There are different examples. So how can you say that it's a copy of your work? Because if you see, I understand your argument that you're saying that look, you have to see the entire copyrighted work, and you have a registration also in your work, but you have to see the similarities, and what are the similarities in this? So the similarities may be many, but what are the similarities you have to identify?
Indeed, Your Honors. Your Honors, again, firstly referencing to the very sentence structure argument that is there. We agree that they would have been making to the similar references. However, Your Honors, there could have been slight difference in them providing, Your Honors, even para 18 of the Moot proposition mentions that there is exact similarities in the words that are referencing to it. Your Honors, the Council will be playing reliance on one of the landmark judgments of the Delhi High Court itself, that is the Ratna Sagar Private Limited versus Frisia publication of 1996. Your Honors, the facts of both the cases are quite similar, and I shall try my best to do justice to the question as well. Your Honors, in this case, the plaintiffs had a book series called Living Science, and on the contrary, the defendants, after a few time, presented their book on unique science. Now, the alleged similarities was on the content and presentation. Your Honors, the bench held in this case that the subject matter, that is nature, plants, and animals, was of common knowledge and cannot be copied. Same agree that in Lotus in our scenario also belongs to the nature. However, they emphasize that even if the subject matter originates from nature, the very presentation, selection, and arrangement of the material constitutes to the original creative expression, and that is what is being contending even in our scenario. Your Honors, had it been just to the expression in the narratives, a benefit of doubt even in the extension could have been provided. However, Your Honors, the similarities does not exist just to that. Your Honors, it is mentioned in the Moot proposition para 18 that even the background of the photographs was of textile hand-woven background. Your Honors, that is the visual similarity that exists. Your Honor, further, if we see the technical annotations that are being used by both are also the same. They are also referencing to the same 13th segment. They are referring to the same color palette. They are referring, indeed, Your Honor.
Just to take it forward from what fell from Justice Karia, you see,
Indeed, Your Honor.
for copyright infringement under Section 14, you have a right to prevent reproduction of the work or any substantial part.
Indeed, Your Honor.
But if the reproduction is not of the whole work or of any substantial part, but I have picked up contents from the book, there is no copyright infringement. If I am writing a book, I will look at 10 references and pick up from whatever I find very useful and write my own book.
Indeed,
If you
Your
look
Honor.
if you look at the judgment in paragraph 16 of the judgment, your case has been set out. And according to your case, which you have pointed out to the learned trial court, you are only able to show similarities on account of some similarities on page 8, page 15, then page 22, and then you go on page 134. So if your book is over 100 pages, and if there are only few pages which you find similarities, how does it render the defendant's book as reproduction or a substantial reproduction?
Thank you so much, Bench, for the question. Your Honors, if we pay reference to the Moot para number 9, it is that they got the book on 18th March 2024. However, Your Honors, the allocation of the research allocation was also at that time only, and the very suspicion lies in the chronology of the dates that follows after that. Your Honor's reference, this shall be dealt in detail by my co-counsel in the rebuttals. However, pertaining to why we are referencing that in the entire idea of a booklet is being copied in there. Your Honors, it must be noted that for in infringement to exist under Section 51, and as if I read it,
So
so that is
idea is not just one second. Idea is not protected, right? It's only the expression which is protected.
indeed, Your Honors.
So your argument that the idea is copied, how do
Indeed, Your Honors.
you claim a protection under the copyright law?
Indeed, Your Honors. Your Honors, it shall be noted that the very idea was limited to giving references in the lotus symbolism to the deities and the mantras. However, Your Honors, there is evidence that if we read Annexure A and Annexure R, which were earlier shown in the exhibit, the very sentence structure, the very chronology that follows is similar. That is the expression carried on by the appellant, and that is being infringed, Your Honors. Your Honors, further, if we look at the another exhibit that has the symbols of evolution of both the designs, Your Honors, clear visual similarities are established even in that. Your Honors, if I may share it in a minute.
Yes.
And that is the reason why that not just mere expression, as Your Honors were mentioning, that if it is just, Your Honors, may I answer this question? It is just that as the honorable bench was claiming that it is if I'm writing a book, I'll be mentioning to certain things mentioned in the another book. Agreed, Your Honors. Your Honors, however, it must be noted that when we are existing in the similar textile industry, I would make sure that my work creates substantial differences. Your Honor, that brings me to the section 51 that talks about infringement of copyright. Your Honors, it reads that when a person without license granted by the due owner of the copyright does anything, the exclusive right to do by which is by the act conferred upon the owner of the copyright, the owner has the exclusive right under this matter under Section 14. Your Honor, if we divide this section into the four major essentials per se, it is the existence of a valid copyright that is already established. Secondly, the ownership by the plaintiff. Your Honor, Anya is the sole author and the copyright owner in the pertinent matter. Your Honor's reference shall be made at the very beginning of this section provides that there is absence of license and permission. Had it been the case that respondents had approached us or had been utilizing our the reproduction of our copyrighted material had been in that sense, the case would have been entirely different. However, the given absence of license shall be noted. Indeed, Your Honors.
Now, Counsel, you have tried to establish the originality of your work. But
Indeed,
how can you be sure that the respondent's work is not original?
Indeed, Your Honor.
Maybe like your work is original, we don't deny their work can also be original.
Indeed, Your Honors. Your Honors, to answer this question, the reliance is made upon Arnstein versus Potter case. However, it is a US Supreme Court case, but it was a landmark case which held that in the situations where there exist substantial similarities and when there is not the two materials are not identical, but there exist substantial similarities between the two. Your Honors, the two tests laid down in this pertinent case were that firstly, that copying shall be established and improper appropriation. Your Honors, to put the second test first, that there is improper appropriation that makes the work not original, as held in, again, coming back to R.G. Anand versus Deluxe Films, it is clearly referred that improper appropriation, that is the unlawful reproduction of protected expression, takes place. The Supreme Court held that while ideas are open for all, the particular expression of idea is exclusive to the author, and if the viewers find resemblance so close that the copy reminds them of the original author, that is what is happening in our case also, Your Honors, then infringement is established. Your Honors, it must be noted, Your Honors, the counsel seeks permission of extension in this argument. Much obliged, Your Honors. Your Honors, and coming back to the similarities, that is the another part of the very test, that is on copying. The literary similarity exists given the near exact paragraphs that have been copied. Your Honors, in para 18 of the Moot proposition, it mentions that the comparison between the two revealed that paragraphs describe lotus symbolism with 127 words in Anya's book and 118 words in Lakshjora's booklet, followed by the description of geometric principles. We agree that the lotus temple belongs to public domain. However, the expression in which it is presented, the geometric description that is provided, that is where our originality lies, Your Honor. The very color palette of not sticking lotus just to its pink color coordination, but bringing it to the amber light, that is where the originality lies, and that is where her 47 original photographs taken, followed by the 23 hand-drawn sketches attached in her booklet, comes into the scenario. Your Honors, just to quickly sum up, my fourth contention, which deals with the reliefs and damages. Much obliged, Your Honors. Your Honors, the contention 4 that the appellant is entitled to reliefs in the pertinent matter submits that the commercial court at Nexaria ordered for permanent injunction and delivery up of destruction with damages of 50 lakh and costs of 2,000. However, Your Honours, it is pleaded before the Honourable Bench that the preventive remedies of permanent injunction and delivery up and destruction shall be given to the appellant, followed by damages also under the Copyrights Act, since both the essentials under the Copyrights Act Section 55, which provides all these cumulative remedies, lays down the two major essentials that the person claiming such injunctions and damages shall be the owner of the copyright, followed by that there shall be infringement of copyright. Since both these essentials are established, the council seeks the damages of 70 lakh along with costs of 4 lakh. Your Honours, the council has come up to this figure of 70 lakh per se with great calculation that given that in the market our booklet was priced each at 2,500, given that out of which after these claims of infringement it was 660 books were not sold. And if we multiply that, that brings us to the figure nearly around 17 lakh, given along with the damages which were earlier provided by the trial court of 50 lakh, the cumulative amount comes to 70 lakh. Your Honours, if the bench has no further question, the council seeks permission to state the prayer.
Yes.
Much obliged, Your Honours. An extension for a minute.
Yes.
Much obliged, Your Honours. Wherefore, in the lights of the facts of the case, issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed before this Honourable High Court of Nexaria to graciously be pleased to declare that the Commercial Court has rightly upheld that the respondent's design infringes the appellant's registered design, that there is no error on the part of the Commercial Court in determining that the use of eternal blossom constitutes infringement under the Trademark Act, that the trial court erred in holding that there was no copyright infringement under the Copyrights Act, that the appellant is entitled to the remedies of permanent injunction and delivery up and destruction in regards to trademark, design, and copyright infringement, along with the damages of 70,000 and the costs of 4 lakh shall be imposed on the respondent, and or pass any other judgment, decree, order, or direction which the bench deems fit in the best interests of justice, equity, and good conscience. And for this act of kindness, the councils, on behalf of the appellants, as in duty bound, shall forever pray.
Yes.
With my lord's permission, may I address the bench as your lordships?
Yes.
Much obliged, your lordships. Your lordship, I am the counsel on behalf of the respondent in the case of Artisan Heritage Private Limited versus Lakshora Textiles Private Limited. Your lordship, the respondent has approached this honorable court by way of counter appeal under section 96 of the Code of Civil Procedure against the judgment passed by the Honorable Learned Commercial Court in Nexaria in its original suit number 142 of 2025, whereby the Learned Court had partly decreed the suit, your lordships. Your lordship, I shall be addressing issue number 1, 2, while my co-counsel will be dealing with issue number 3 and 4. With my lord's permission,
Yes.
may I proceed with the facts of the case?
Facts we are aware of, so you can skip the facts.
My lord, there are certain facts to be brought on record before this honorable court.
Okay, then you proceed in your own way. Yes.
Yes, my lord. Your lordship, the respondent Luxora Textile Private Limited is a textile company based in Nigeria City, operating 28 retail stores along with an online platform, your lordships. Your lordship, Luxora's design team is headed by Ms. Priya Verma and Ms. Neha Kapoor. Your lordship, they are known for producing modern and trend-oriented motifs. In late 2023, Luxora created a new titled collection named as Eternal Blossom. The lotus motif was consisting of 13 triangular segments arranged in spiral bind, inspired by the sacred geometry and in traditional textile art, your lordship. Your lordship, Luxura relies on the internal communication and dated drafts and also third-party references to show that this design was independently conceived, your lordship. Your lordship, the Eternal Blossom collection was launched on 15 January 2024 and achieved a substantial commercial success, generating approximately 8.5 crore profit, your lordship. Subsequently, a trademark application for Eternal Blossom was also filed on 10th of January 2024, which is pending till date, your lordships. Accordingly, your lordships, Luxura submits that its artistic expression, color schemes, as well as the use of public domain inspiration give the collection a distinct and original character in itself, your lordship. On 25th of November 2024, the appellant Artisan Heritage Private Limited issued a cease and desist notice alleging the infringement of their design, trademark, and copyrights, your lordships. Luxura clearly denied these allegations, asserting that lotus motif and geometric patterns are common cultural themes and not the exclusive property of any of the entity, your lordship. In its original suit number 142 of 2025, the appellants relied on the expert reports indicating that market confusions are there. Well, the respondent produced evidences of independent creation and other trademark infringement, lordship. By the judgment dated 15th March 2025, the learned commercial court held that the respondent is liable for design and trademark infringement. But your lordship, it dismissed the copyright claim. Your lordship, both the parties have now approached this honorable court where the appellant has filed a first regular appeal and the respondents have filed a counter appeal under Order 41, Rule 22 of CPC. With my lord's permission, may I proceed with the issues of this case?
Yes.
Much obliged, your lordships. Your lordship, issue number 1 deals with whether the respondent's design, that is Eternal Blossom, infringes the appellant's registered design, that is the Eternal Bloom, within the meaning of Section 22 of the Designs Act. My lord, it is our respectful submission that the findings of the infringement is incorrect because, your lordship, the appellant's design lacks novelty and stands prior published before getting the registration, and in any case, the respondent's design is materially different and independently created. Your lordship, the respondent acknowledged that the appellant holds a registration, design registration, which is in Annexure A1 for Eternal Bloom under the Designs Act. But however, your lordship, in the case, I would like to ask permission of the court to screen share the judgment. I'll be
Yes.
sharing.
Yes.
Nikki Tasha Private Limited versus Faridabad Gas Gadgets. Yes, my lord. My lord, over here, in this judgment, your lordship, this was before the Honorable Delhi High Court. The court held that certificate does not establish a conclusive right. It has to be tried and tested in the laboratory of courts, your lordship. Your lordship, if we come to Annexure A1, I hope my lordships have the copy of the annexures.
Yes.
Yes, my lord. If my lord comes to Annexure A,
Yes.
my lord, over here, the date of registration is of 12th August 2022.
Correct.
My lord, if my lord comes to Moot proposition,
Yes.
para 2,
Hmm.
third line,
Correct.
she began using this design commercially on her products from April 2022. My lord, if we go to the provisions of the Designs Act of Section 4 of the Designs Act,
Yes.
prohibition of registration of certain designs, clause B. It has been, if may I read the section, my lord.
Yes.
Section 4B clearly defines that has been disclosed to the public anywhere in India or in any country by publication in tangible form or by use or in any other way prior to the filing date. My lord, the filing date as per the Annexure A1 is 12th of August 2022. And my lord, the defense which has been taken by the appellants are they use commercially. They are giving a plea of benefit of doubt. Your lordship, using commercially means to use something in a way that is connected with the buying and selling of the good. Your lordship, this is a clear violation of the whole Designs Act, your lordship, because the appellants have already published it before getting the design registration itself, your lordship. And this directly goes to Section 19 of the Designs Act, wherein there is cancellation of the registration, because there is a violation of that particular section, your lordship. If we read the cancellation of registration, yes, my lord.
So why did you not approach the appropriate forum for cancellation of the design?
My lord, as per the facts of the case, there is no mention of the cancellation of the design registration in the judgment as well as in the facts of the case. So, my lord, we cannot go beyond the facts of the case, and that's the reason, my lord, we have brought on record before this honorable court stating that the very certificate of design registration is illegal, your lordship, because the.
All right.
Yes, my lord. My lord, coming to first issues, first issue's fault. My lord, another fact is that if we see Moot proposition, paragraph number 1, over here, your lordship, prior to establishing a studio, Ananya worked as, one second, my lord. My lord, as per the facts of the case, in the present case, both the designers, that is the appellant Ms. Ananya Malhotra, whereas the respondent, which is Priya Verma, had earlier worked at Heritage Textile together, your lordship. During that period, they were involved in developing traditional Indian motifs and geometric lotus patterns, your lordship. These earlier works establishes the fact that the appellant's design had already existed. This is not the first one which has been invented by the appellants in their case, as well as in respondent's case, your lordship. These motifs were already present. And my lords, coming to judgment of ad print versus Mohan impression, your lordship, in this judgment, it was held that prior publication does not require mass circulation. Even limited availability to a member of public is sufficient, your lordship. Therefore, it is clearly stated that and established that certain Indian motifs and certain geometric structures were already present in the market, your lordship. Thus, your lordship, the appellant's design fails the test of newness and originality, and therefore cannot form for the basis of an infringement claim, your lordship. Coming to the second fault, the respondent's design is not an imitation, your lordship. It's materially different. If your lordship comes to R3, R1, Annexure R1. I hope my lord is on Annexure R1.
Yes, R1.
Your lordship, even we assume that the appellant's design is valid, there is no infringement of design because, your lordship, it is distinct in its overall visual impression. Now, my lords, if come to R3, Annexure R3, last page. My lord is on the same page.
Yes.
My lord, over here, the structural diagram is given of eternal bloom, which is the design which we have created. Annexure R3, last page.
Yes.
My lord, there are total 13 segments, inner tire 5 segments, middle tire 4 segments, outer tire 4 segments. Similarly, your lordship now may refer to annexure A3. Annexure A3, last page.
Yes.
Which is the diagram provided or the design provided by the appearance. Over here, there is a clear mention of 27.7 degree variables. And there are radius, central circle radius 25 units and other units. Your Lordship, if we compare both the designs, they may use 13 segments, but the resemblance ends there, Your Lordship. Firstly, there is difference in the angular spacing, Your Lordship. The appellant has used 27.7 degree intervals, and the respondent's design doesn't contain 27.7 degree variables in it, Your Lordship. There is nowhere mentioned in the design that they have used. Yes, my lord.
Now, the thing is that the similarity between designs is not a question of mathematical precision.
Indeed,
It is
my
the
lord.
look and feel test.
Indeed, Your Lordship. Indeed, Your Lordship.
If we go by your argument that just twisting the percentages a little can take you away from the pale of infringement, always.
Indeed, Your Lordship. We are not
That
pressing
cannot be
on the.
accepted.
Indeed, my lord. We are not pressing on the fact that there are some different variables used by our respondent. My lord, if my lord comes to color palette in R1, which is the booklet of the respondent, over there, your lordship, if we see the color palettes used are golden earth, bronze sun, warm top, and desert sand, your lordship. The color which is used by the respondents are golden, by the appellants are golden in nature, your lordship. There are different color patterns used in this segment, your lordship, as described in the booklet. The overall look changes with this little impressions, your lordship. Even if, my lord, there's a case of Hawkins Cooker versus Zavir Chand. It is the Honorable Bombay High Court's judgment. Your lordship, in that case, it was held that it's now settled that even a slight innovation or improvement in the design is a design by itself and can be registered as independently innovative design. Your lordship, this minute or small changes, even that matters, your lordship, in this type of cases. Your lordship, I would like to state the facts of this case of the judgment which I have cited. Your lordship, over here, the Hawkins Cooker is one of the premium brand which produces the cookers. And Zavir Chand is a similar company which produces the cookers and other utensils, your lordship. Your lordship, now the claim was made by Hawkins. Hawkins alleged that Zavir Chand fraudulently imitated their registered design for a tawa which they marketed under the Hawkins trade. And your lordship, Zavir Chand argued that this design was distinct, and the court found that even minor innovations or improvements could create a separate registrable design, your lordship. This was held in the court. Only the difference was that in this case, the lid of the whole utensil was different. Your lordship, such a minor change also created an huge impact, and the plaintiff who was Hawkins, the case was dismissed on this basis, your lordship. Going on with your arguments, your lordship, coming to third fault. Yes, my lord.
May I ask a question?
Yes, my lord.
Can you explain to us, according to you, what is the test of infringement of a design?
My lord, for infringement of the design, first, I appeal, your lordship, as per the facts. Firstly,
no, test. I'm not on the facts. What is the test of infringement?
My lord, for the test of infringement, firstly, regarding the my lord, I would like to cite one of the judgment.
Counsel, I'm asking you to give your answer from what is stated in Section 22 of the Designs Act. You don't have to refer to any judgment.
Yes, my lord. As per Section 22, my lord, piracy of a registered design, it has to see whether the sale or the class of the design which has been produced, it's
Obvious or fraudulent imitation. That's the
yes,
test.
my lord. Yes, my lord. Regarding the fraudulent and the registered proprietor of the design, and your lordship, ordinary observed test, all these are implied, your lordship.
So
Lordship,
in
yes,
facts of your case, if an ordinary person with average intelligence with imperfect recollection sees these two designs, what is the test here? Whether that person would be able to distinguish one design from the other?
My lord, for this, in my further arguments, I would like to argue, but your lordship, just giving a brief. My lord, the price are variable. The eternal bloom is different sector, as well as Luxura Eternal Blossom is different, my lord. Luxura is a main brand, is a prominent brand, wherein a collection is Eternal Blossom. Your lordship, there is a
No, that is trademark. See, ultimately we are talking about design.
design.
And in design, the segment doesn't matter. You may sell the same product for 10 times more the price. But
Yes,
if
my
there is a design infringement, then you can't get away by saying that, look, my price range is different and therefore I am entitled to infringe the design,
My lord,
registered design.
in order to conclude the fact that whether the design is infringed or not, you have to look to how it has been created, your lordship. Regarding the, my lord, my third fold is regarding the independent creation and absence of access, that this design was created and we have copied it. My lord, I'll be dealing with it.
No, but you yourself is saying that, look, they had started commercial productions way back, and therefore it was in public domain. That
Yes,
is
my
your
lord,
argument. Yes.
it was in the public domain, your lordship. There is no
So,
dispute.
so where is the proof that you didn't have access?
My lord may come to, as alleged by the respondents in moot proposition paragraph number 9.
Yes.
My lord, the very contention of the appellants are that uh, purchase records indicate that during this period, the design team procured 3 copies of The Philosophy of Eternal Bloom by Ananya Malhotra on 18th March from online retailer bookversa.com, subscription to Design Quarterly Urbania commencing 24. Your Lordship, if we read continuingly, and various other design books and materials related to the geometric patterns and Indian textiles and contemporary design trends were also purchased, Your Lordship. This is not the case that only the
No,
appellate book
no.
has been purchased.
You argued that there was no access. My
Yes, my lord.
question to you is very simple: is
Yes, yes,
that the facts are not the same as what you are arguing.
yes,
There was an access which is provided in the facts itself, as well as you may see other 10 books as well, but that doesn't mean that you had no access to the design of the
ma-
appellant.
yes, my lord. My lord may come to page annexure R3,
R3. Okay.
which is a booklet produced by the respondent.
Yes.
R3, page number 3, the
Yes.
design development progression.
Yeah. Yes.
My lord, if we see the diagrams, over here, the first diagram was initiated on November 23.
No, no. Now you have to see the final diagram. In January 2024, see, you may have previous steps available for your design creation, but ultimately you'll have to see what was the final design which you adopted. And
Yes,
you
my
have to
lord.
compare that with the appellant's design
There
side
are,
by side. And that is what the learned commercial court has done. So you have to show us what are the grounds of appeal on which you find any error or misunderstanding by the learned commercial court.
my lord, as firstly stated regarding the certificate of design registration,
Yes,
that document itself is invalid and we are disputing
but
on
that is not the argument you had
Yes,
made
yes,
before
yes.
the learned trial court. You can't raise the fresh arguments in the appellate court.
Indeed, Your Lordship, considering the fact, but Your Lordship, it is important to bring on record the facts which were
No, this is the argument which was available to you during the trial as well and the final hearing, but you chose not to raise this point. Now you can't raise this as a first time in the appeal.
indeed, Your
You
Lordship.
never gave the opportunity to London trial court to examine this aspect.
My lord, the judgment is silent on these facts as well as the moot proposition is silent on this fact whether this
Just
argument.
some time back, you said that you can't travel beyond the facts. You yourself gave an answer to us saying that the facts are sacrosanct and you can't travel beyond it. So you can't answer that question. Now you yourself is traveling beyond the facts.
My lord, even if we consider that we have not argued before the learned commercial court regarding the whole dispute of the certificate of design, my lord, if we compare the design, we have established the fact that there is some difference, and we have cited a judgment of Hawking Cooker versus Zaverchan. If there is a slight change, even if there is a slight change in the design, only that even that can be independently taken as a design, Your Lordship. To conclude, Your Lordship, all the reasons placed before this honorable court. Firstly, Your Lordship, lack of nobility and prior publication has been done by the appellants. Secondly, Your Lordship, there is a clear design difference. As established, there is color difference as well as the angular spacing which has been provided. It is very much different, Your Lordship. Secondly, coming to the independent creation, which has been already established, and the absence of access, Your Lordship. The book was purchased on 18th of March 2024, and the design has been already created prior to it, which was from November 23rd to December 2023, Your Lordship. With this, my lord, I shall ask the permission to proceed with my issue number 2.
Yes.
Much obliged, Your Lordship. My lord, the issue number 2 is that whether the trial court correctly held that the eternal blossom does not infringe or is not deceptively similar to eternal bloom under the Trademarks Act, Your Lordship. Your Lordship, the respectful submission on behalf of the respondent is that the learned trial court applied the law correctly and reached the right conclusion in holding that the respondent's mark eternal blossom does not infringe the appellant's mark eternal bloom, Your Lordship. Your Lordship, my arguments for this issue will be in three folds. Firstly, the two marks which is the eternal blossom and eternal bloom, are totally different, Your Lordship. Your Lordship, under Section 29 of the Trademarks Act, infringement arises only if the impugned mark, when viewed as a whole, is likely to confuse or deceive the customer. Your Lordship, in our case, bloom and blossom differ in meaning, spelling, pronunciation, and phonetic flow, Your Lordship. Your Lordship, if we see the word bloom, it ends with a shorter sound, and if we go to the blossom, it ends with a softer two-syllable sound, Your Lordship. Overall, if we look the whole word, the overall look and the sound of two marks are therefore not similar, Your Lordship. They give a different meaning, and no entity can take a stand upon that this word cannot be used anywhere, Your Lordship. This is a word which can be used in daily use as well, Your Lordship. Moreover, Your Lordship, I would like to cite a judgment in Kunj. My lord, in Kunj Aluminium versus Conical Phillips.
Oh, counsel, your time remaining is very short, so please don't cite these judgments now. Come to your substantive arguments.
My lord, I'll directly come to the appellant's registration, trademark registration. If my lord comes to Annexure A2, Annexure A2 is the trademark register, which has been provided.
Yes, we have it. Yes.
My lord, even if we compare the marks, the appellant's trademark right themselves are defective, Your Lordship. If my lord comes to date of advertisement,
Yes, we have it.
last line, it is the 22nd January 2024.
Yes.
My lord, if my lord comes to Section 21 of the Trademarks Act, it
Yes.
states that any person may, within 4 months from the date of advertisement or re-advertisement of an application for registration, can give notice in writing in prescribed manner, and on payment of the such fees may be prescribed to registrar of opposition to the registration. My lord, the statutory period which has been allotted to this is that within 4 months, any objection can be raised.
Yes.
My lord, if my lord sees the date of registration, it is 5th of March.
Yes.
My lord, it means that the statutory period of 4 months was not included in this. Within 3 months, the applicant has got the trademark register. Your Lordship, this is a clear violation of the whole trademark provision, Your Lordship, which is prematurely on 5th of March 2024, nearly 3 months before the statutory period ends, Your Lordship. Such a premature registration is a procedural irregularity, and therefore the registration cannot be treated as a conclusive evidence, Your Lordship, of valid under Section 31 of Trademarks Act, Your Lordship. The whole trademark certificate itself is forged, Your Lordship, over here, because the trademark has given in within 3 months. The statutory period is for 4 months, Your Lordship. Consequently, Your Lordship, the appellant claim for the exclusivity under Section 28 and 29, which itself loses the legal force, Your Lordship, of this document.
But counsel, you have to take steps to get a mark removed,
Indeed, Your Lordship.
which you have not done. So
Yes,
if you
sir.
have not done, the mark is to be taken as registered.
My lord, again, my lord, the facts are not have been given. My lord, we are ready to go for the cancellation of the trademark as per the appropriate authorities, Your Lordship. this fact is just brought on record before this honorable court, stating that the very Annexure A2, which is the trademark certificate, it itself is not proper, Your Lordship. It's illegal. In short, Your Lordship, the
But the
appellant,
issues were framed in this case, right?
yes, my lord.
Issues were framed, right?
Issues were framed, Your Lordship.
So why there was no issue of invalidity framed by you?
My lord, beg your pardon. Issues were framed in Moot proposition.
Okay,
That's what I'm asking.
can you, in a suit of infringement, can you counterclaim that the appellant's trademark is not validly registered?
Yes, my lord. My lord, we cannot claim in this before this honorable court. We are just bringing on record the fact that as the annexure has been attached before this honorable court, that the trademark has been already registered. But we see the procedural aspect wherein 1 month has not been provided to us. If 1 month extra was provided, then we can get a benefit of doubt that we would have filed the petition regarding the illegality of that trademark, Your Lordship. Your Lordship, in short, the appellant did not possess perfect or valid trademark rights at the time of the alleged infringement, Your Lordship. Thirdly, my lord, coming to the third fault, the respondent adopted eternal, my lord, I think the time has been exceeded. My major point was regarding the trademark certificate itself in terms of issues. And secondly, the commercial presence which our respondents have been seen is that the appellant's commercial presence is extremely limited. Only 2.3 crores they have collected within two years, Your Lordship. In contrast, if we see the respondent collection earned 8.5 crores in 4 months, Your Lordship, showing strong independent recognition. If my lord comes to Annexure R2, sorry, my lord. If my lord comes to R2, the invoices which are attached of our company. Point number 6, invoices and sale records. If my lord sees the price variation, there is a huge gap between the price range. Your Lordship, before any consumer purchases any of the product, he will see that whether he can buy that product or not, Your Lordship. Hence, there is no likelihood of confusion in this case, Your Lordship. The appellant heavily relies on the self-conducted surveys and social media screenshots, Your Lordship. Such evidence is unreliable and legally inadmissible in the whole, Your Lordship. Secondly, Your Lordship, the appellant has not shown any of the instances wherein the payments have been misdirected, or the misdelivery of product has been done, or there is mistaken trade inquiries, or the retailer confusion. Your Lordship, all these points have been not put on by the appellants, stating that these were the confusion wherein the consumer was affected. Your Lordship, there is no instance in that. The products which were purchased by our consumers were clear with it, and we have gained 8.5 crores in 4 months, Your Lordship. And the other part, 2 years have been gone, Your Lordship. The profit gained by the appellants are very minimal, Your Lordship. 2.3 crores have been gained. Therefore, Your Lordship, I would like to conclude my issues. My co-counsel will be dealing with issue number 3 and 4.
Yes.
May it please your lordship, I'm counsel 2 for the respondent, and I will address why the trial court correctly dismissed the copyright infringement and why no appellate interference is warranted in our particular case. Your lordship, the trial court correctly applied copyright law principles. The judgment is legally sound and factually supported and consistent with the settled law. And let me explain you why in my 5 folds. Firstly, the idea expression liability. Under section 13(1)(a), with section 2(c) of the copyright, it protects original expression, not ideas. And I would like to cite a judgment to support my argument, that is R.G. Anand versus Deluxe Films. In this judgment, it was held that categorically held if 2 works are based on the same idea but expressed differently, there is no infringement, even if similarities exist. The appellant's eternal bloom and our eternal blossom share only the idea of a lotus, a universal artistic concept which is incapable of private ownership. Geometric symmetry, concentric petals, and radial composition are conventional features of a floral motif, your lordships, not predictable or not protectable expressions. The trial court here in our matter had compared both the works in Annexure J. If your lordships would come to Annexure J, para 12 and para 17, they found the clear differences in the petals and the shape and the configuration, the color palette and the gradient and overall artistic impression. These distinctions materially alter the look and feel, neglecting substantial reproduction. Secondly, the merger doctrine applies, your lordship. In the case of Eastern Book Company versus DB Modak, it established the idea expression dichotomy limits protection to individual expression, not underlying concepts. The merger doctrine applies where an idea can only be expressed in limited ways. Ideas and expression merge and the copyright protection ceases. The lotus here can only be depicted through certain natural geometric forms, that is, petals, symmetry, and proportions, rendering expression scope inherently limited. The appellant's claim effectively seeks to monopolize the lotus from itself, which is contrary to the intellectual property law. The idea and expression are inseparable and no exclusive right subsets. The trial court and hence has rightly applied this doctrine in our favor. Any similarity which results from the intrinsic subject matter, the limitations are of not copying. Our internal creative drafts and the digital design records, which comes to Annexure R2, which shows that the evidence of independent design processes and established bona fide authorship, refuting any copying presumptions, your lordships. Thirdly, the access argument. The appellant claims that we have purchased our book, so we copied. This is mere speculation. Mere opportunity or thematic overlap cannot establish copying without probative similarity. Even striking resemblance doesn't constitute infringement if the defendant's work was independently created. Our document design development, that is Annexure R2, fully supports an independent creation. We researched multiple sources, temple architecture, traditional motifs, historical compendiums. The appellant's book was one among the many references that we have taken, not the sole source, your lordship. The design process involved multiple iteration, independent creative choices, distinct aesthetics and directions. Coming to the point of the similarity, your lordships, which the appellant are claiming, the 86% similarity claim is mathematically misleading. Dr. Kumar measured the geometric parameters dictated by the subject matter. When two designers geometrically abstract the same radial flower, mathematical similarities are inevitable. Not evidence of copying. The qualitative differences and rounded versus the sharp metals, ornate versus the minimalistic treatments, and the gradient coloring versus the monochrome demonstrates independent expression of work. Fourthly, the trial court findings deserve the difference. After conducting detailed visual analysis, that is the Annexure J provided by the proposition, the court found that the appellant design is inspired, not wholly original. And our work possesses distinct artistic identity. And similarities are identical and not substantial. These are factual determination based on the expert evidence and judicial comparison. Our work differs fundamentally. The Eternal Blossom embodies contemporary reinterpretation of the cultural motifs, which are consistent with our roots of Arvania theme. The Eternal Bloom remains a minimalistic geometric abstraction. They represent different artistic visions addressing the same cultural symbol. Fifth, your lordship, that extending copyright to universal cultural symbols like lotus would create undue monopolies and stifle the artistic innovation. The Copyright Act balances the private right with public access, ensuring the ideas from collective heritage, which remains free. In the case of Eastern Book Company, the court held that the originality requires creative labor and skill and not mere adaptation from the familiar forms. The appellant in our case, that is the lotus abstraction, while competent, it's not so original or so unique as to preclude others from creating their own geometric lotus designs. Copyright law never intended to grant the monopolies over the entire artistic genres or cultural motifs. Upholding the trial court's decision, yes, your lordship.
The council, the copyright law never requires the work to be unique in order to grant it protection. Even though the appellant's work is not unique, as you said, still protection can be granted as long as it is original.
Yes, indeed, your lordship. Coming to that point that the work of the appellant and our respondent, we are not similar. The appellant is claiming that we have copied, and they are claiming that they're trying to claim a monopoly over the design, that just because the lotus design has been made by them, only they can use it. And that exactly our entire point is, that they cannot create a monopoly over a commonly found design in our own culture. Your Lordship, if I may continue with my arguments.
Please, you
Coming
can,
to issue number. Yes, Your Lordship.
you can please continue.
Yes. Coming to the issue number 4, that is, no appellate interference is warranted in our case. Your Lordship, under Section 96 of the Civil Procedure Code, appellate interference requires contrary findings, ignored evidence, or legal misapplication, none of which exists here in our case. The trial court correctly applied the informed user test under the Bharat class tube to design claims properly assessed, which is phonetic, visual, and conceptually similarity for the trademark claims, and correctly applied the idea expression dichotomy and merger doctrine to copyright claims under the R.G. Anand case and the Eastern Book Company case. The appellant seeks reappreciation of the factual findings, which is impermissible. The trial court examined evidence and heard the expert testimony, conducted visual comparisons, and reached the reasoned conclusions. The court found that the appellate designs draw from the public domain. Our designs are independently created with distinct aesthetics. The alleged
Counsel,
similarity.
Counsel, I have one question. Is that
Yes, Your
what is
Lordship.
the copyright you are claiming? You are claiming the copyright into the design or the booklet?
Booklet, Your Lordship.
Okay, but your argument seems to be that the design is not copied. So that is very confusing for this court.
Apologies, my lord. I'll come to the point and further argue on the copyright claims. Regarding the booklet. Regarding the appellate's claim for the cumulative protection across 3 regimes, this approach is legally questionable, Your Lordship. While design, trademark, and copyright can theoretically coexist, they serve different purposes and have different requirements. The appellant cannot use one regime to bootstrap claims under the another, and each must be independently established for the same. The design claims fail because the registered design lacks sufficient originality and appropriates public domain geometric forms. Your Lordship, coming to the case of the Nikitasha Private Limited versus Faridabad Gas Gadgets, the Delhi High Court held that we must not forget that the registered design of the plaintiff is of recent date. In the recent case of the monopoly, which is seriously disputed on various grounds such as prior publication and lack of originality, trade variation, etc., it will not be proper to grant an injunction, Your Lordship. This principle was further reinforced in Royalta Auto Components Private Limited versus Jaspal Singh, where the court rejected the argument of the plaintiff and observed that in the event of registration of design of the recent date, whether injunction should continue or on an account of registration of design when there is a serious dispute or prior publication of the design. The law is well settled that an injunction will not follow as a matter of routine. Applying these principles, Your Lordship, the appellant's design registration dates only from August 2022. That is less than 3 years old at the time of the suit. This qualifies as recent under the established precedent. Moreover, our defense raises serious disputes on multiple grounds. That is, prior publication through Heritage Textiles Limited, where both the designers worked during the duration of 2016 to 2018. There is lack of originality as the geometric lotus exists in the public domain. Coming to the point that trademark claim fails because the marks use common descriptive terms and targeting that consumers are likely to be confused. The copyright claim fails because only the idea, not the expression, is shared. Rejecting all 3 claims is internally consistent, not contradictory, Your Lordships. The real issue here is the cultural heritage versus the private monopoly, Your Lordships. The fundamental question is whether one designer can privatize a cultural symbol through strategic intellectual property registrations. The lotus appears in Indian art dating back millennia. Temple cravings, then religious paintings, textile patterns, architectural ornamentation. It represents purity, enlightenment, spiritual awakening across Hinduism, Buddhism, and Jainism. It is India's known flower. When the appellant geometrically abstract this cultural symbol using the naturally occurring mathematical proportions, the golden ratio that is, found throughout the nature, the Fibonacci series appearing in flower petal arrangements, can the appellant actually claim exclusive rights, preventing others from creating their own geometric versions of lotus interpretations? And we must submit the answer must be no, your lordships. The law carefully balances the creation with preserving public access to the cultural heritage. The appellant's registration, if upheld too broadly, would effectively prohibit other designers from working with the geometric lotus forms, descriptive floral language, and even the traditional Indian motifs. This would impoverish our shared culture vocabulary and contradict the fundamental policy of the intellectual property law. Across all three regimes, the courts have consistently held that cultural symbols, natural forms, and descriptive language remain available for all to use in their own way. The appellant had every right to create her geometric lotus and protect her specific commercial expression, but she does not have the right to exclude others from the entire field of geometric lotus design. That distinction between protecting one's own expression and monopolizing the underlying concept is the cornerstone of the basic intellectual property law. Your Lordship, even if this court were to incline to find some degree of similarity warranting the concern, the appropriate response is not the relief sought by the appellant. She seeks permanent injunction, destruction of all our materials, damages, accounts of profits, and collective corrective advertising. This would effectively shut down our entire roots of Armenian collection, destroying significant investment and harming our business reputation. It's important to note that the equitable discretion must temper remedies to prevent unjust enrichment or overprotection. If any similarity does exist, Your Lordship, it is marginal and confined to inevitable geometric overlap. When two designers independently abstract the same cultural symbol, the appropriate remedy, if any, would be modest, perhaps requiring us to add another feature or clarifying disclaimers or not destroying the entire product line for the sake of it. The appellant's sale of rupees 2.3 crores over 2 years suggests a small scale operation. Eternal Blossom collection launched only in October 2024, Your Lordship. That is 5 months before this appeal. The alleged damage is speculative and limited, and any relief must be proportionate to the actual harm and not punitive. Your Lordship, I must emphasize a documented creative process. That is on the annexure R2, if you may come to. Your Lordships are with me?
Yes.
Point one, Your Lordship, that Moot boards from Jan 2024 showing temple architecture research from across India. Second, that design sheets from Feb to March 2024 showing multiple lotus iteration with different petal. That is 8, 13, 16, 21. Again, third point, that the color palette development from March 2024, exploring various gradient schemes. Then meeting notes from a design team discussing capturing of the Armenian heritage and contemporary interpretation of the traditional beliefs and the motifs. And finally, the design selections in September 2024, with the rationale explaining why we chose 13 petals, Your Lordship. We chose this because it's an auspicious number in the Vedic tradition, and the rounded forms, which is because rounded forms are more softer and more feminine in aesthetic. This documentation predates our October 2024 launch and demonstrates genuine independent creation. The appellant dismisses this as fabricated, but offers no evidence of fabrication, Your Lordship. These are contemporary business records created in the ordinary course, bearing strong indica of reliability. Also comparing this with the appellant's evidence of copying, that is book purchase, which we acknowledge as research, then professional connection through Miss Verma, which ended 6 years ago, Your Lordship, and geometric similarity, which again we have shown is inevitable when abstracting same natural form. The appellant has circumstantially access evidence, but no direct evidence of copying. We have affirmative evidence of independent creation. The balance tips in our favor, Your Lordship. Again, coming to the market reality, Your Lordship, both brands have coexisted since October 2024, over 6 months. If genuine confusion existed, we would have expected significant evidence, that is return, complaint to consumer forums, media coverage outlet, and industry commentary questioning our practices, none of which those exist in the public forum as of today. The appellant survey is the only evidence and its methodology is suspect. Small sample, Leading questions, artificial test conditioning, showing both products side by side, which never actually happens in the retail environment, your lordships. And the real world commerce, consumers encounter product sequentially, not comparatively. They see Luxura branding, our distinct packaging, our price points, which differ from the appellants, your lordship. Our retail presence is the most important. We sell through major departmental stores, and the appellant sells through the boutique and online. The 14 social media posted and 12 customer inquiries over the 6 months from a combined social media audience of hundreds of thousands represent a negligible of 0.02% interaction rate. This is just the statistical noise, your lordship, not a systematic confusion. Isolated instances of confusion are insufficient to be, yes, your lordship.
Now, you mentioned about side-by-side comparison. Is side-by-side comparison anywhere prohibited in the practice of copyright law?
Coming to the point, lordship, that there has to be no likelihood of the confusion. The appellant
Likelihood
here,
of confusion is a test in trademark law, but you are arguing on copyright law.
yes.
So please confine to copyright law.
Yes, your lordship. Apologies. Coming to the point of, if I may conclude with a prayer for the same.
All right.
So you haven't answered the question which has come from the bench. Is a side-by-side comparison against the test of copyright infringement, or it's permissible?
It is not permissible, your lordship, as per my knowledge. I may beg to differ for the same.
What is the basis of that knowledge?
Yes, your lordship.
What is the basis of your knowledge that it's not permissible?
I may take 30 seconds to answer the question.
All right.
The lordship, we can compare the copyrighted works in a descriptive way, such as summarizing themes or explaining differences, or comparative styles, or analyzing ideas, as long as we don't provide the request of large chunks of the copyrighted text. It's permissible. But if we again go word to word, then it's not permissible.
All right, but where you have not cited, which law says so? Why it is not? You say it is not permissible, but which law says so? Which is your material? On what basis you rely?
Copyright law, your lordships.
Which copyright law? You can just say law, right? That way, you have to tell us the provision of copyright law, which disallows that.
My lord, I'll just go through the provision and get back to you on the same.
Sure, you should do that.
Yes, your lordship. Apologies, my lordship. If I may proceed with a prayer, your lordship.
You can proceed with a prayer, but just try to answer the question or say that you are not able to find the material, the relevant material. Then you can proceed.
Your lordship, I may require more 30 seconds to conclude the same.
Yeah, all right.
As per my research, your lordship, there are no specific copyright provision where anywhere it says that side-by-side comparison cannot be done. I'm not able to find the provision. If your lordship may tell me the provision for my knowledge.
All right,
I
then
would
you
be-
can. Now it's enough. You can please proceed with your prayer.
Much obliged, your lordships. Apologies, my lordships. Wherefore, in the lights of the facts stated, issues raised, authorities cited, and arguments advanced, it is most respectfully prayed before this honorable court that it may be pleased to set aside the finding of the design infringement under Section 22 of the Designs Act 2000 and hold that the respondent's design, Eternal Blossom, is an independent artistic creation inspired by public domain lotus motifs, devoid of the fraudulent or obvious imitation of the appellant's work. Reverse the trial court finding of the infringement under Section 29 of the Trademarks Act 1999 and declare that the mark Eternal Blossom is phonetically, visually, and conceptually distinct, comprising common descriptive terms incapable of exclusive appropriation, with no likelihood of confusion or deception in the relevant market. Affirm the learned trial court's finding that no copyright infringement is made out, as both works share only the idea of lotus, a public domain theme, and that the respondent's design represents independent expression and original creation within the meaning of Section 13 and 51 of the Copyright Act 1957. Fourth, allow the appeal by reversing the erroneous finding on design and trademark infringement while affirming the dismissal of the copyright claim, and set aside or suitably modify any injunctive or relief granted against the respondent, including claims for damages, and grant such order or further reliefs as this honorable court may deem fit, equitable, just, and proper in the interest of justice.
Yes, you want to proceed with rebuttals?
Much obliged, Your Honors. Your Honors, I'll be tackling the rebuttals and I'll be going in. Firstly, I'll be tackling the issue of design, then the trademark, and then at last the Copyright Act. Firstly, in regards to the design, infringement in regards to the design, it is humbly submitted, Your Honors, as the respondents have mentioned that Priya Verma and Anya Malhotra, Priya Verma, the lead designer at Luxora, were in contact with each other. Actually, Priya Verma was the senior designer at the place where Anya Malhotra earlier worked. So it is safe to assume that they had certain connections, they had certain communications, and the fact that they had worked together on a similar creation means
So
that
we are in appeal. So you must have led evidence before the learned commercial court.
indeed,
Nothing
Your Honors.
on record shows that there was any discussion with regard to this particular design between them when they were working 5-6 years before together. So what is the when you say safe to assume, in appeal we can't assume, right? This is not a theoretical question. This is a real appeal under Section 96, where we have to appreciate the evidence led by you before the learned commercial court. So what is the evidence you have led that
Much obliged.
they have exchanged this idea of design?
Much obliged, Your Honors. Your Honors, the annexure that you have mentioned says that they were not in contact for the 5-6 years when they were working, after they were working together. However, connection or communication are something different. She might have kept tabs. Even if we leave aside this argument as something that is insignificant, our major point of contention is if they consider our design to be invalid, why have they not raised a concern under Section 19 of the Designs Act, which deals with cancellation of the design? Why was this remedy not taken earlier? Why was this remedy not taken at the trial stage? And why is this remedy being mentioned only at the appellate stage? Your Honors, it would be safe to presume that this is an afterthought. They did not think of this when the design was in the market. What makes them think that the design is invalid only when
So at the appellate stage, and the question of law can be raised, right? This is a question of law they are raising, is that, look, as per Section 21, it should not be priorly published design. You have started using this design prior to the date of priority. The date of priority is in August. You started using it 6 months before. So that is the legal argument they have raised. So why can't they raise legal argument at the appellate stage?
Much obliged, Your Honors. Your Honors, factually, we have proof that under Section 4B, the factual matrix state commercial use. Now, commercial use, can you include manufacturing as well? We could have started manufacturing during that stage. We could have started working on the products,
No, could
designing.
have. You are the appellant. You must know the facts. You can't just say I would have done it. Now I'll
Much
assume
obliged.
that. See, you are instructed by your client. Your client must know whether they started
Much
producing, they
obliged.
started selling, or it's a question of fact. Why are you assuming every fact?
Much obliged, Your Honors. The council seeks humble apologies. However, it was merely highlighted that they have connoted that commercial use could only mean publication. We are disputing the fact that commercial use could only mean publication. Additionally, Your Honors, it is submitted that for a design application to be granted in August 2022, the application must have been filed by April 2022. Additionally, Your Honors, coming to the point of Section 19, once again, it is submitted. They can raise it at this stage, no doubt regarding that. However, the chain of circumstances in the present matter, wherein firstly they have copied our design, we filed a suit, and after that they have raised this concern. After that, they have raised the validity of the design should be under question. Additionally, Your Honor, it is also submitted that this is a fashion brand, fast fashion brand. They come up with collection every 6 to 8 months. Now, this is why they need little brands like ours an extension, if Your Honors may.
How many minutes?
2 minutes, Your Honors.
Okay.
Much obliged, Your Honors. That is why it would be safe to assume that they have copied our design. Coming to the point of trademark, even if our trademark certification is not valid, it is submitted that they are still liable under the common law action of passing off, Your Honors. They cannot, even if we are not validly registered, they cannot portray our products as their own. Therefore, liability arises under the common law action of passing off, Your Honors. In regards to the third point regarding copyright law, it is humbly submitted. Then, additionally, Your Honor, the color scheme, they argue that the golden yellowish colors and the yellow colors which they have used are different. However, this seems to be a little redundant submission because the test has to be of the consumers, of the eye. The eye is not generally able to distinguish between such peculiarities of the colors. Coming to the point of copyright infringement, it is submitted that in the case of Armstein versus Porter, two-factor test was laid down to establish copyright infringement. First is copying, and second is improper appropriation. It is submitted both have been satisfied in the pertinent matter, and also that the defense of independent creation requires no knowledge of the appellant's work, no exposure to the appellant's work. They had prior knowledge, reliance placed on paragraph 9 of the Moot proposition, wherein they had acquired our material and they also had exposure to our work. Additionally, Your Honors, they say that they have depicted the design, how they came up with the design. Your Honors, counsel seeks permission to share the screen for a minute.
Yes.
Your Honors, this is what the evolution of design in the appellant's story of eternal bloom looks like. And Your Honors, just a second, just making this point. And this is what it looks like in the respondent's work. Organic form, development to a nascent stage, similar development, the second picture, and the third picture, which is the final product. Thereby, Your Honors, it is humbly contended that that appellant's case stands strong. Much obliged, Your Honors.
My lord,
Yes.
in the issues which we had argued, we have already established the fact that regarding the annexure A1, which pertaining to design registration certificate. Secondly, with respect to the trademark. Now the learned respondent counsel had stated that under section 19 of the Designs Act, we could have gone to the cancellation of registration to the appropriate authority. Your Lordship, if we see the bare perusal of the section, Your Lordship, it has been clearly written that any person interested may present a petition for the cancellation of registration of a design at any time after the registration of design, Your Lordship. Even if in this moment also, my lord, we can file the petition. If it is the fact only that the facts are silent on this thing, so my lord, we would like to bring on record that the section says that it can be filed at any time, Your Lordship, after the registration of the design. Secondly, my lord, the exhibits which were displayed by the appellants, Your Lordship, during the arguments, issue number 1, Your Lordship, the issues were the annexures were different, Your Lordship, and the pictures which were shown by the appearance were different, Your Lordship. They had created that image, so it was looking the similar, Your Lordship. Well, they have presented it right now by showing the annexure, Your Lordship. There is a difference between both the things. Just I want to highlight it, Your Lordship. Secondly, Your Lordship, regarding the purchase of booklets, which is in 18th March 2024, and we have showed the developments. My lord, we cannot do argument on the basis of the fact that this purchase was made prior or before. But Your Lordship, the differences between the design as well as what are the minor changes, what was held in the case of Hawkins versus Zavir Chand has already been established, and we have argued a lot in that matter, Your Lordship. Therefore, I conclude my rebuttals, Your Lordship.
Are you trying to say that they've shown some different documents? Because if you see what they showed on the screen was from Annexure A,
My lord,
8.3, and then what they showed was designed from your own booklet on Annexure R3.
my
So
lord,
are you alleging that they are misleading this court?
my lord, the image which was showed in the first issue during the initial arguments, I would like to bring up on the record that the image which was shown prior to this, they have marked it as Exhibit B. They had marked it as Exhibit B. During the initial arguments, they showed that image. That was drawn, Your Lordship. That was not the annexure which has been marked or given by the organizers.
Your Honors, if I may be
Yes.
given a
Yes,
chance to speak,
what is the answer to that
Your
allegation?
Honors, a reference being made in Exhibit B was to page number 11 of the annexures, Annexure R1. It states Luxora Eternal Blossom Collection Spring Summer / 2024, Eternal Blossom Silk Sari, and the symbol. I have this for the reference of the code, but if you could open page number 11 of Annexure R1, and also
Yeah.
in design registration certificate of the appellant, page number 2. These were the images that were present in regards to the Exhibit B, which was portrayed.
But what
But
is Exhibit B? Why have you termed it as Exhibit B?
Your Honors, will share the screen as to showcase the Exhibit B.
Is it
This,
part of the record? Exhibit B is part of record.
indeed, Your Honors, it is a part of our record, and we have taken these images from the annexures only. Annexure page number 2 and page number 11 of the annexures.
Page number 2.
Page number 2 and page number 11. Annexure A1 and R1.
R1. Yes, it's the same.
Indeed, much
But-
obliged, Your Honors.
My lord, it was written as it was handwritten like appellant's design, and so my lord, we just thought to bring on record that the
Yes,
annexures
yes.
are provided.
Correct. No, that's why we gave them chance to clarify. No problem.
That's all, my lord.
That was a creative exercise on our part to label them exclusively for the ease of the code, since they were not side by side compared anywhere in the annexures. Therefore, we took this
Yes,
liberty.
but
Your
you
Honors.
should give the reference also if you're creating something.
Indeed, the council seeks humble apologies, Your Honors.
Yes.
It was an honor to argue before this bench, Your Lordships.
Yes.
If the lordships are satisfied, may I seek permission to wrap up the courtroom?
Yes, please.
With this, the overall rounds of the final session of the second FICCI CLC Moot Court Competition 2025 stands concluded. I thank you, the honorable judges, Honorable Mr. Justice Tejas Karya, Judge Delhi High Court, Mr. Raman Mittal, Professor, Campus Law Center, Mr. Hemant Singh, partner, managing partner at Intel Advocate. We extend our gratitude to the judges for educating the rounds. Ms. Meda, you may proceed.
Yeah, so I request all the participants to kindly stay here, and the honorable judges will be directed to a breakout room where they will be filling their score sheet, and then the result announcement will happen.
be starting with the validity shortly in 5 minutes.
A very good evening to all. As we assemble for the valedictory session of this prestigious event, it is my privilege to welcome our eminent dignitaries whose presence and wisdom truly elevated today's proceedings. We are honored to have Honorable Mr. Justice Tejas Karia, who currently serves as the Judge of Delhi High Court. Honorable Justice Tejas Karia holds an LLB from ILS Law College, Pune, and 2 LLM degrees, one in corporate laws from the University of Gujarat, and another in international arbitration and IT laws from the London School of Economics. Beginning his practice at Ahmedabad City Civil Court, he later practiced at the Gujarat High Court, handling a variety of civil, criminal, and appellate matters. Sir shifted practice to High Court of Delhi in 2004 and joined Amarchand Mangaldas and Company. He has appeared before high courts across India, erstwhile Company Law Board, Securities Appellate Tribunal, National Company Law Tribunals, National Company Law Appellate Tribunal, National Green Tribunal, National Consumer Redressal Commission, Appellate Tribunal for Electricity, and the Supreme Court of India in landmark cases. Specialized in field of international and domestic commercial arbitration, Sir has handled complex, high-value, ad hoc and institutional arbitrations across diverse industry sectors, having seats in India, London, and Singapore as a counsel before arbitration tribunals and the courts in the matters involving appointment of arbitrators, interim measures, challenge, and enforcement of arbitration awards. Recognized widely as a leading arbitration expert, Sir is dual qualified in India and England and Wales and is a fellow of Chartered Institute of Arbitrators, London. He was appointed as Judge of the Delhi High Court on 14 February 2025, notably one of the first judges appointed from an arbitration practice and law firm background. We welcome you, sir. We are also privileged to have Professor Dr. Raman Mittal, a distinguished academician and authority in the discipline of law. Professor Dr. Raman Mittal is a professor at the Faculty of Law, University of Delhi, and serves as a leading authority in intellectual property law, contract law, and he holds an LLB, LLM, and a gold medal PhD from Punjab University. Dr. Mittal brings over 2 decades of experience in academia, research, and consultancy in the legal field. His career includes serving as visiting faculty at prestigious institutions such as the Max Planck Institute for IP Law in Munich and at the Indian Law Institute. Professor Mittal is known for landmark research and publications in cyberspace law, copyright, trademark, and personality rights, which have influenced legal education and practice in India. He is highly regarded by students and peers for excellence in teaching, extensive legal writing, and active engagement in shaping policy debates around contemporary legal issues. Finally, we are privileged to have with us Mr. Hemant Singh, a leading figure in intellectual property law. Mr. Singh is a leading intellectual property litigator, currently the founder and managing partner at Intel Advocare, which is based in Delhi and Mumbai. Admitted to the bar in 1984, Mr. Singh has handled over 4,000 IP litigation across Indian courts, covering trademarks, patents, designs, copyright, and competition law. He is a registered patent agent and regularly represents Fortune 100 and 500 companies and global clients. Mr. Singh's experience and expertise has significantly shaped IP jurisprudence in India. He is celebrated for his role in policy development and for contributing as a mentor to upcoming IP professionals. Mr. Singh serves as the president of AIPPI and has previously served on the board of directors of INTA. He is often recognized among India's top IP practitioners and is valued for practical legal advice, client representation, and thought leadership in the IP domain. Thank you, esteemed dignitaries, for sharing your time and expertise with us today. Your presence is a source of inspiration, and we are grateful for your invaluable contributions. I now hand over the virtual floor to your lordship to deliver the special address. Sir.
Thank you, Ms. Ruchita Singh, for the kind introduction. Professor Dr. Raman Mittal, Faculty of Law, University of Delhi. Mr. Hemant Singh, founder and managing partner, Intel Advocates. All the participants and the students. It's indeed my honor and privilege to address all of you today at this valedictory ceremony of second FICCI CLC National Moot Court competition on a very interesting topic of intellectual property. And this event, the competition has done a great benefit to all those who participated in this event by bringing all of you together to have an experience in the field of intellectual property law. As we all know, intellectual property law is highly specialized practice area, and to get an exposure at such an early age, while you are young minds shaping your career, it will really going to benefit you, all of you, when you decide your career options in future. This kind of opportunities gives all of you immense learning opportunity and the growth. Mooting per se, I feel in many ways is one of the most rigorous forms of legal training. It places all the participants in the environment where the practice of law truly unfolds. In fact, it gives you a real life experience of the court. You have to deal with complex facts, competing narratives, give answers to very difficult questions. Also develop your drafting skills are tested, your oral arguments, the way you make it is very important, and the power of persuasion. You have to persuade the court of your point of view, and at the same time answer all the questions being put to you and deal with the questions of law as well. What it really requires is the clarity of thought, teamwork, temperament, research capability. You must be having a very good research ability to understand the facts and apply to the existing case laws. And also discipline and presence of mind. You have to think while you are arguing, because many a times you don't anticipate the questions, but if you have prepared well, I'm sure you will be able to answer every question. The problem or the proposition for this moot court competition was also very well crafted. It involved all the aspects of intellectual property law, passing of copyright, designs, trademark, except patent, everything was there. So it gave you a very good overview of the entire gamut of intellectual property law. And it was not merely an academic exercise. In fact, what we see, and I'm sitting in the intellectual property division of Delhi High Court at present, and I see this type of arguments being made on daily basis in High Court of Delhi. So the moot proposition was real, it was contemporary, and it was really an impression of the real life court arguments. There were issues, of course, you all answered it very well. Say copyright issues of the registered design, how to deal with it, the clash between two similar trademarks, the debate over originality and expression, idea expression dichotomy in the realm of copyright, questions of passing off. I didn't hear much of the arguments on passing off from all of you, but again, passing off is a common law right in addition to the statutory rights available under our statutes of copyright, designs, and trademark. And the confusion, the test of confusion. Ultimately, the intellectual property laws are centered around protecting the brands and also not creating the confusion amongst the users. So this year's proposition, I felt, touched upon all the various tests and doctrines that define the very soul of the intellectual property jurisprudence. So I really congratulate each one of you for participating in this competition. Winning and losing doesn't matter. In my view, the experience what you get while merely participating in this kind of events itself is sufficient, and this will stay very for a very long time with you. So ultimately, what you need to understand is the underlying theme of the intellectual property law. You need to understand the spirit behind the IP protection, why we protect designs, why trademarks matter for maintaining consumer trust, why copyright safeguards original expression, and also at the same time, we need to also strike a balance between the creativity and a fair competition. These are all the realities of modern commerce, where the branding and aesthetics are critical market drivers. The companies move very quickly to capture trends, and if you see the proposition also, the time gap between the two parties adopting the similar marks is not big. So it all about trends, because it's all about fashion. The brands go by the trends with the social media and the influencing which has on the minds of people. You have to be there to make profit. So ultimately, the courts also have to act very swiftly. In Delhi, we grant ex parte ad interim injunctions and protect the intellectual property, and that's why we see more and more cases coming to Delhi as compared to other high courts. Also, I saw that all of you had prepared very well. You had very good legal arguments. Even your compendium of cases, which we saw, was well researched. It gives you the personal growth and the professional developments. I'm sure all of you would have spent weeks and months researching and drafting the propositions, preparing for submissions, making various practice rounds for your oral submissions, anticipating questions and debating with your teammates on all these aspects. Uh, what I feel personally is that the strength of argument is not mostly in the volume, but in the clarity. You have to come across as a very clear and articulate counsel. So therefore, a good lawyer is someone who is able to explain the case in simple language and able to understand the questions from the judge and answer it there and there. For that, you need a lot of preparation. Uh, Ultimately, all of you may or may not end up in the litigation. You have various options, but if you do practice in the courts, you have to develop all these skills, and today's experience will or last 2 days experience will really help you to develop that skill set. I must also congratulate FICCI and CLC for creating this platform for the young and budding lawyers who are going to really gain value from this experience. FICCI has been contributing a lot on the IP side. It has played a major role to shape a robust and innovation-friendly IP landscape in India. And the commitment of FICCI in creating platforms like this is really commendable. Uh, at the same time, CLC requires special mentions because the CLC has, with its long and distinguished history, has produced number of jurists, CJIs, Supreme Court judges, various High Court judges across, and it continues to remain a cornerstone of legal education in India. It emphasizes on the practical engagement, mooting, debate, discussions, and academic excellence has shaped generation of lawyers for decades. So I'm sure this event is going to add to the skill set which we have seen today that the participants have developed. Also, the organizing committee has done a great job. All the student conveners, volunteers, the everyone working behind the scenes, from starting from creating the problems. I've seen there were a lot of clarifications given also. So your dedication and hard work has ensured the smooth completion of this competition. And lastly, but not the least, all the participants, whether you win or lose today, you must know that all of you are winners. Winners in the sense that you participated, you gained experience, you worked under pressure, you wanted to learn and delivered your best. These skills which you have developed will remain with you for long, even after this competition. And if you have experienced the first-hand experience of arguing in a court with the experts on the uh, intellectual property side, one professor, one lawyer, and one real judge. So I think this was a great opportunity for you to learn. It was a good way to learn the law of intellectual property law. Uh, what really is required is courage to speak. You all have come over that inhibition to speak, the curiosity to question, and also ability to understand. So this competition has given you a lot of this experience, and you have already demonstrated these qualities while arguing your respective cases. I really congratulate all of you, and especially the winning team, who have worked very, very hard for that. And also equal congratulations to the runner-up and all the participants, because you all have pushed your boundaries, and you have strengthened your skills, contributed to the intellectual spirit of this experience. I'm sure this experience is going to inspire you to participate in many more such competitions in future. Sharpen your advocacy skills, deepen your engagement with law, and also if you feel it may also give you an opportunity to pursue the domain law of intellectual property law. What we need today is the young minds like yours, minds that are curious, dedicated, thoughtful, and courageous. So it was my privilege to be part of this event. I wish each one of you a very best in your journey ahead. You may carry forward the lessons you have learned here, and they will guide you as you step into the multifaceted, challenging, and profoundly meaningful world of legal practice. Thank you, and congratulations to all of you.
Thank you, Your Lordship, for the address. Your profound insights and inspiring words have truly enlightened us and will resonate deeply as we move forward. Now we move on to the important section of the valedictory session, that is the result announcement. First and foremost, we congratulate all the participants for the spirited involvement in this competition. Each team has put forth a tough fight, demonstrating exemplary advocacy and research skills. It has been truly an enriching and rewarding journey for everyone involved. To announce the winner and runner of the second FICCI CLC National Virtual Moot Court Competition 2025, it is my esteemed honor to invite His Lordship to declare the results.
I haven't received the. Have you sent me the results? Mr. Kalra, have you
So the
sent?
results have been shared on your email ID. I'll share them to you on the personal chat itself.
Okay. So my email would have gone to my personal secretary, so I haven't received your email. Yes, I have got it now. Okay, so I've got the results now. So I will start with the best speaker. The best speaker for second FICCI CLC Virtual National Moot Court Competition 2025 is, any guesses? Okay. Best speaker is Stuti Maheshwari from BITS Law School. Congratulations. Now, best memorial is goes to the team. Best memorial for second FICCI CLC Virtual National Moot Court Competition 2025 goes to Birla Global University Bhubaneswar. Congratulations. Now, what you have been waiting for, the final results. Okay, so instead of declaring the first runner-up, I would declare the winners because then it will give away the answer. So the winner for second FICCI Virtual National Moot Court Competition 2025 is Army Institute Mohali. Congratulations. And similar congratulations to the runners-up, Thakur Ram Narayan College of Law, Mumbai University. Congratulations to first runner-up as well. Thank you.
We would request all the winners and runners up to please switch on their cameras for a photograph with so.
They are already celebrating. They're not interested in photograph. Congratulations. You did excellent. All of you did fantastic. All the best.
Thank you so
Thank
much,
you so
sir.
much, sir.
Thank you so much, sir.
Thank you, sir.
We request the winners and the runners up to stay in the gallery while we are taking a photograph with sir.
God bless.
Kevin also. Thank you, sir, for the announcement of results. We would like to hand over the virtual floor to Mr. Hemant Singh to deliver the vote of thanks and closing remarks.
Good evening, all. Honorable Mr. Justice Tejas Karya, Professor Dr. Raman Mittal, my colleagues on the bench today, Ruchita, organizers from FICCI and CLC, participants, mentors, and friends. It has been a pleasure to be part of the final round of the second FICCI CLC National Virtual Moot Court Competition 2025. On behalf of the bench, my sincere thanks to everyone who shaped these 2 days. Justice Karya, your thoughts and instructive guidance today has been priceless and key takeaway for all the participants, including myself. It was a privilege to share this moot court bench with you and Professor Mittal. A word of appreciation is also due to the judges who presided over the earlier rounds. Each of you helped set the tone for the quality we saw today. Your feedback, patience, and engagement ensured that the finalists arrived here well tested and well prepared. The strength of any moot rests on the collective wisdom of its judging panel, and this year's competition benefited greatly from yours. To the teams, you carried the weight of a complex IP problem with seriousness and skill. IP today sits at the center of innovation, commerce, and creative expression, and the issues you debated are the very questions we grapple with in real practice on a day-to-day basis. Your preparation showed patience with detail, comfort with nuance, and respect for principle, qualities that will serve you as good lawyers. Whether you argued today or exited earlier, you should be proud of the discipline and commitment. My thanks to FICCI and CLC, University of Delhi, for designing and running this event with such care. Managing a virtual competition at this scale is not easy, yet the process was smooth, structured, and entirely conducive to rigorous argument. To the courtmasters, timekeepers, and volunteers, your quiet efficiency kept the proceedings steady and fair. The strength of any moot rests on the people who manage the flow, and you did that with precision. And to the students who will carry this experience forward, keep your curiosity alive. IP law rewards those who can think analytically while still appreciating creativity and innovation. Continue sharpening your craft and carry the same humility and respect that you showed here into every courtroom and conference room you step into. Thank you for making this edition of FICCI CLC National Virtual Moot such a meaningful experience. I look forward to seeing many of you again, and I wish you all the very best in your journey ahead. Thank you all.
Thank you, sir, for your insightful remarks. Your wisdom and vision have truly inspired us and enriched this event. With that, we would like to conclude the event. We encourage all the participants to join us for the next year moot court competition, and we thank all the dignitaries and the judges for their insights and their feedback to the participants. It has enriched them a lot. Thank you.
Thank you.
Thank you.